Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about COVID delay to trials. Cases that should have gone to the Supreme Court of Canada, but didn't. The Supreme Court of Canada finally had the opportunity to hear a case involving a person whose trial was delayed as a result of shutdowns in the COVID-19 pandemic. There have been numerous cases where challenges to the right to be tried in a reasonable time have been brought as a result of an alleged breach of that right because of steps taken or not taken by the courts and by the justice system as a whole during the COVID-19 pandemic. And unfortunately, the first of those cases to seek leave to the Supreme Court of Canada has been denied leave. And this case obviously raises very important issues. Not only would such a case essentially set a precedent for the future as far as what governments and court services and Crown Counsel and judicial actors are supposed to do when it comes to minimizing or mitigating COVID-19 related delay, but there are a lot of issues arising out of delay that came from the pandemic that are still before the courts and still being litigated. And issues arising out of delay that came as a result of the pandemic raise important questions, like the bounds of the exceptional circumstance exception, which allows a case to be tried and completed over the 18-month mark if exceptional circumstances justify that delay. Identifying where something ceases to be exceptional circumstances and starts being a failure by the parties to act and to find creative solutions to systemic problems like the pandemic's impact on the courts is a significant concern. It is something that should have been addressed by the Supreme Court of Canada. This is particularly so because we saw different approaches taken across Canada to when the courts were up and functioning, different definitions of what the courts were as far as essential service or critical service. Different provinces reopened courts in different ways at different times and had different mechanisms for holding trials and having appearances. And because of all of this, an actual dissection by the Supreme Court of Canada of the steps taken and the steps not taken and identifying where things could have been done better would provide a roadmap for the future should, God forbid, we ever end up in a situation like the pandemic again. And it's very few circumstances that actually get identified as an exceptional circumstance. So articulating and better articulating from the Supreme Court of Canada what is an exceptional circumstance and the outer limits of when an exceptional circumstance starts to be something that is people just acquiescing to delay or being uncareful about delay, like in the time before the Jordan decision, is something the Supreme Court of Canada should have taken the opportunity to chime in on. Hopefully, another case tries to seek leave to the Supreme Court of Canada, and the court takes the opportunity to make these important decisions, to provide a roadmap for the future, and to put our justice system in the best position to provide the meaningful implementation of the right to be tried within a reasonable time. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bold Creative for putting together these videos. Please like, subscribe, and share with your friends.